We had a case recently of a worker who was a painter, and he was painting a bathroom in a school. And to do that, he needed to stand on a ladder because he was painting an area about 13 or 14 feet high on a wall. It was a tall wall. And prior to painting, he was sanding down the wall in order to smooth it out before he would put on the paint. And as he was doing that, he applied pressure, and as a result, the ladder he was on had shifted, he lost his balance, and he fell down. And he injured his ankle very severely. It was an injury that required surgery, and the ankle had to actually be fused, which means that they had to basically eliminate the joint. They had to freeze the joint in place with a screw because there had been some disruption in the joint as a result of the injury. The problem with that meant he would never be able to get on a ladder. He would never be able to do the kinds of things that he needed to do in his previous job. So that was a situation where the worker, first of all, had the very bad injury, and second of all, had damages in the form of medical expenses and also lost earnings. In this particular case, this bore out that the law was very much on our side, particularly when workers are working at heights. The law is very strict and very clear. That is the obligation of the owner and the general contractor to provide what's called proper protection. They have to make sure that the workers are adequately protected from the risk that is posed by working at a height. So if a worker is high up working, whether it's on a scaffold, whether it's on a ladder, or any other type of a situation, the owner has a strict obligation to make sure that there are proper safety devices in place to make sure that the worker is protected. And if that doesn't happen, then the owner can and should be held responsible under the law, and that's what happened in that case.